Yes, good evening to the aspirants of the 2022 JCJ main examination, which may be in the November month, but the date is still not notified. And read what I posted on the screen so that you could know that I am with you and you are with me, and both are traveling or sailing the same boat to reach to the destination. Read. Unmute and read what I posted on the screen.
Welcome to my online class for students of JCJ 2022 main exam. It's about Civil Procedure Code. Professor Dr. Mohammed Saheb Hussain, Professor of Law, School of Law, St. Augustine University of Tanzania, Mazwa, Tanzania, EA.
Yes, welcome. Very nice. This is a code of procedure and everything followed over time, so and so. So this all is called hodgepodge. That is a specific name is there. What is that? Hodgepodge. HOTCH, hodge, space POTCH. It is like a brawl, BRAWL, brawl. Means mixture of everything. Are you following me?
Okay.
Yeah, because it shows the every aspect of the civil procedure code that actually it says. Now let us see what it contains. And here civil procedure code, that is 1908 bird's eye view, means what it says. Bird's eye view means a sketch, a outline. That is the phraseology. Repeat.
Bird's eye view.
Means it's a phraseology.
This is the physiology.
Yes. Very good, very good. But somebody is speaking in your background. I could hear their voice also. Yes, anyway, let's come to the point. Definitions generally would be there in the section 2. What is another name for the definition? If you know it, you tell me. If you don't know it, you say pass on.
Pass on.
Excuse me. The another name for the definition is explanatory clause. Repeat.
Yes. Explanatory clause.
Very good, very good. So now let's see the decree, judgment, and order. And this I have explained you, but let us see in detail in this one. The term decree is defined in the section 2, subsection. Can you say subsection 2 or clause 2? Anyone?
Actually, it's a clause, and generally definitions are we mention as clause.
So let me check it because I put it here. I downloaded just now, Civil Procedure Code. Okay, Bear Act, yeah. I downloaded just now. Yes. So let me see whether it is a section 2, class 2 or section 2, subsection 2. Let us see, it will be seen over here. See, this is section 1, where it is short title, commencement and extent. Okay. Then comes to section 2, definitions. In this act, unless there is anything repugnant in the subject or context, here 1 is given. So when such a thing comes as a tale and later 1 comes, we say it is a class 1. And if directly comes without this tail, we can say section 2, subsection 2. Did you get my point?
Sir.
See, this explanation is there. Later on, if anything comes, we say section 2, class 1. And code includes rules. This is section 2, class 2, decree. And this one, what do you say? Now you tell me. Section 2, class 2, say this one.
Section 2, class 2, subclass A.
Okay, we can say here class 1, subclass A. Yeah, we can say like that. Yeah, it is true. So now, section 2, class 2, decree means the formal expression of an adjudication which so far as regards the court expressing it conclusively determines the right of the particular parties, rights of the parties with regard to the all or any of the matters in controversy in the suit and may be either preliminary or final, both the way. It shall be deemed to include the rejection of a plaint and the determination of any question within. Suppose the plaint rejection is there, we can also say decree. Or section 144, but shall not include, of course, they have given the subclasses. And here, section 2, class 2, we will say, is it not? So, decree as follows judgment, it is based upon a judgment. So, it follows the judgment. It follows the judgment which comes first.
First.
Decree comes first and later judgment.
Yes, sir.
So, judgment first, decree later. Is it clear?
Yes, sir.
And is based upon a judgment. And the decree is always based on a judgment. Now it is divided into 5 types. What? Judgments. Unlike the judgments, which is final in itself, a decree may be final or preliminary, just before we read it. It is a formal declaration or adjudication, means disposition, is a conclusive in nature. A decree is of 3 kinds, namely, what do you say, namely in short terminology, in shortening form? If you know it, you tell me. If you don't know it, you say pass on.
Pass on.
VIZ, Viz, capital VIZ. Actually, the full form it is videlicet, is the Latin terminology. So VIZ, or we can say namely preliminary decree, final decree, and partly preliminary and partly final. So 3 types of the decrees are there. Either the decree may be the preliminary, or it is a final, or it is partly preliminary and partly final. Means mixed, 50-50. A decree may be delivered with an order. So, judgment first. What would be the following? Decree is second, and order is the last. A decree may be delivered with an order. A order would be passed over there. The decree contains the outcome of the suit and conclusively determines the right of the parties with regard to the issue in dispute in the suit. After passing the decree, the suit stands disposed of since the rights of the parties are finally determined by the court. So, what are the parties' rights should be there in that dispute? That would be the conclusively made in the final decree. So, what is the sequence now? Among the 3, that is decree, judgment, and order.
Order, judgment, decree.
Is it? First, judgment.
Orders can be made in one suit.
Yes.
And decree finally conclusively determines the rights of the party. So decree is the last, and judgment, upon the judgment one brings
Here you check it here. See, a decree, here I will clearly mention. See, a decree may be final or preliminary, okay. But here it's a decree always follows judgment. Then which is first?
judgment.
Then decree follows. But decree rights judgment, rights of the persons of the parties to the dispute will be delivered in the form of a order. See, a decree may be delivered with an order. So the decree
Okay.
contains the outcome of the suit, conclusively determines the right of the parties. So first one is judgment, subject to the correction. Second one is decree,
Decree.
and it is the shape is in the order form. So what is the sequence?
Judgment, decree, order.
That is the sequence. Of course, if I may be wrong, you can correct me also. Or if any listener also listening, then he may correct me because I am also a human being. But I studied a bit earlier, that's why I know it. You're studying now, that's why you are learning now. So the decree contains that so and so thing. So parties regarding the so order will be passed at the finally. The first one is judgment, next one is decree, next is order. So deemed decree. What is deemed decree? A decree shall be deemed to include the rejection of a plaint and any question within section 144 of the Code of Civil Procedure 1908, but shall not include. So it is a decree deemed to be rejection of a plaint. Of course, regarding the section 144 of the section civil procedure, then it shall not include. What shall not include? Let us see. Any such sentence or adjudication or disposition from which it appears that an appeal lies on an appeal from an order or any such order of the discharge dismissal of default. It shall not, when you say not final decree, when there is a scope of the appeal. So, but shall not include, it is not a final, not include, that's why justification here given is a adjudication which it appears that an appeal lies as an appeal from an order. So, it is an appeal lies as an appeal from an order, and such a thing will not be made final. Any such order of the discharge dismissal of default. There is a likelihood of a, because whenever the judgments are given, sometimes no, they will give also in the judgment or order. If the party is not satisfied, it they can appeal also. Even that thing also they will given because the scope is given over there. Of course, if it is not given over there, also agreed party definitely will approach to the
Court.
approach to the
Court, sir.
Monda Market, Secunderabad. Is it?
No, sir.
Is it?
No, sir.
Approach to the higher court.
Higher court.
If you are not happy with the lower court decision, then you can have every right to approach to the higher
Appellate court.
court. So now we will see the kinds of decrees. According to section 2, class 2 of the Code of Civil Procedure 1908, decrees are divided into three categories. We just read it before. Number 1, preliminary decree. In general sense, in general sense, God is saying grammatical mistake. In a general sense, the word preliminary means preparation of the main matter. Initial or introductory or preparatory. That is the preliminary decree. In a legal sense, a preliminary decree is a decree where further proceedings have to take place before the suit can be disposed of. So, a preliminary decree would be given over there in the beginning of it. And when the suit will be complete disposed of, before that a decree would be given, it's said to be the preliminary decree. It decides, what it decides preliminary decree? It decides the right of the parties in respect to, actually in respect to, no, the right of the parties with respect to all or any of the matters of discussion, but it does not completely dispose of the suit. So it will make a presumption in one way, in another way, the right of the parties in the subject matter. Of course, later on it will be proved whether right is there or not. If it is not there, then the decree will be dismissed. No more. So it does not completely dispose the suit. It is not the disposal of the suit. It is the primarily relief will be given. In such a decree, the rights and liabilities of the parties are stated, leaving the actual result or decision to be worked out in future proceedings. So in the decree, what will be there? Right and liabilities of the parties are stated. Whether it is proved or not proved, it is final proceedings are over, then it will be decided, worked out in future proceedings. A preliminary decree is passed in those cases where the proceedings are to be carried out in two different stages. At that instance only, this preliminary decree will be passed. What are they? A preliminary decree is passed in those cases, in which cases where the proceedings are to be carried out in two different stages. What are they? The first stage is when the right of the parties are adjudicated, and the second stage is whose those rights are implemented or executed. In the two stages should be comes over there whether the parties having the right or not, or such rights are can be implemented or executed or not. In such a situations, preliminary decree would be sanctioned. It will be delivered. Then final decree. The final decree is a disposition of the case. Am I right? In general sense, not in general sense, in a general sense, the word final means last one, ultimate one, conclusive one, end one, or decisive. In the legal sense, in a legal sense, or in the legal sense, in a legal sense, a final decree is a decree which completely disposes of the suit and settles all the questions in discussion between the parties, and nothing is left for the deciding thereafter. So it is a completely whether rights are available or not available over there, it is clearly proved in that dispute of the suit. At that instance, we can say it is a final decree. It is only said to be final when such adjudication is completely disposes of the suit. When the completely disposition of the suit would be there in a particular court, then we can say the final decree. After the final decree, can an aggrieved person having a right to appeal or not? Yes?
No, sir, if it is final decree, appellate court will not be.
So one cannot go to the appeal.
Yes, sir.
If a person is not satisfied by the decree of a court, can't he approach to the another court, higher court? Yes?
When it is final, it cannot go. If it is already decided by appellate court, it cannot go.
One can go from the district court, either if the civil matter is concerned, a criminal matter is concerned, to the appeal. Of course, he may show the lower court has narrated or explained or assumed or followed a different expression in particular case, word. Then they can approach. The final decree here in the sense, it will establish as the end of the result of the dispute. And then only you can say it's the final decree. But doesn't mean that a party cannot have a right to go to the court. As per my knowledge goes. Let us see that, because law will not stop any person in most of the cases go to the appeal. Even murder cases. Is it a final, the district court? Answer is no. They can
No,
take
it
in a
can go
different
for
view.
appeal.
They can appeal to the High Court. If they fail in the High Court, does it mean that the execution of the death sentence would be there? Answer is no. They can approach to the Supreme Court of India. If the Supreme Court of India is given the death sentence, let you presume it. Is it a final? Answer is
Yes.
no. They can go to the president for the mercy.
Oh, yeah.
Is it or not?
Yes, sir, President.
See, I took the mercy petition. I told you. I took the murder case. That's the reason, not the civil case.
Yeah, yes, sir.
Especially I mentioned. So, but in certain respects, that is a binding one. But most of the people, they say the interpretation of the lower court is taken the different view, and hence we are aggrieved by the decision of the lower court, and appeal can be made on the argument, made on the points whether the High Court will admit it or dismiss it. So partly preliminary and partly final means 50-50. A decree is said to be the partly preliminary and partly final when the court decides two questions by the same decree. If there is the two questions, for instance, if the court passes a decree in favor of one party along with the direction of inquiry for the other party, means they will give the decree, but along with the direction of the inquiry, again the inquiry should be made. It is made to the other party. That means it is a partly preliminary and partly final. The former part of the decree is final, while the later part is the preliminary. Final to the first party, but preliminary to the second party, because still the inquiry should be taken, for which further proceedings have to take place. For example, in a suit of a possession of the property with the company C, if the court passes a decree of the possession of the property in favor of the plaintiff and directs an inquiry into the company C, then the former part of the decree is final decree, while the later part of is the preliminary decree to the company. So that is the thing they say, partly preliminary, partly final. See, partly final to the first party and partly preliminary to the second party, because still the inquiry should be done. That is the reason we can say the partly preliminary and partly final decree. The necessity of a decree. What is the necessity of a decree when the judgment is already given? So they say the Code of Civil Procedure requires the passing of a decree in all the suits. It must be there. A decree is based upon judgment. So which is come first?
Judgment, sir.
Judgment come first. Based on the judgment, the decree can be made. Who is liable and who has to pay the compensation and who has to give the possession, who has to be dispossessed, because these are all the civil suits. And that is the reason they say decree is based upon the judgment and is also follows a judgment. And first judgment, next the content of the judgment will be made clear in the decree, which is the reason why it is an indispensable and essential requisite. Which is an essential requisite? Participants. Participants, are you sleeping? Please reply. Say don't know. Participants, which is a prerequisite?
Judgment is a prerequisite for decree.
Wrong. Decree is a prerequisite. Decree is essential. Of course, don't say word pre, requisite. Of course, when you say prerequisite means judgment should be there.
Yes, sir.
Yes, prerequisite means judgment should be there. Requisite means decree is requisite. And indispensable means necessarily must be there. What? Decree. Is it clear? Say yes.
Yes, sir.
Good. What is the spelling of judgment, please?
In general, we don't write E in the judgment. Judgment.
There is no E after G. That is the style we are adapting. So, judgment spelling is Judgment. So, the decree is indispensable or an absolute requisite. It is an essential part of the ultimate outcome of the suit. An appeal can be made against a decree and not against a judgment.
Judgment.
If the decree is absent, an appeal cannot be put in motion because decree is indispensable for the judgment. Is it clear? One cannot appeal on the judgment, but one can appeal on the
Decree.
decree. Good. Can you read this one? Yes.
Contents of a decree. A decree always follows the judgment, coincides with it, and contains the suit's number. Every suit has a particular number and it should be mentioned in the decree. The names, description, and registered addresses of the parties. Every decree shall have the names of all the parties of that particular suit, the proper description of the parties of the suit, and the registered addresses of all the parties of the suit. The
Enough.
particular
Enough. So, what is the elements or ingredients or essentials or the content or the input of a decree? So, a decree always follows the judgment and coincides with it and contains what? The suit's number. Every suit has a particular number and it should be mentioned in the decree. A suit number is there. And the names and description and registered addresses of the parties. Every decree shall have the names of all the parties, that particular suit, the proper description of the parties of the suit. That means name of the person. Next. Qualification of a person. Is it? Height of a person. Color of a person. Is it? Say.
no, sir.
No, sir.
Then what should be?
Name and particulars of the
age.
person, sir. Address, residential address.
Name and father's name.
His residential address.
Age. Occupation. Residential address. Is it the sequence? Or sequence should be changed?
His religion will also be there, sir.
Of course, there are certain places they may change it, but general phenomena is first name, next father name, next age, next occupation, next address. General. Okay, I will ask you one IQ question. Whether we have to write the WhatsApp number first or email later, or email first and WhatsApp number later. Which is the right sequence?
First WhatsApp number, then email,
First the
sir.
phone, then.
Generally, you may have seen in the most of the places, WhatsApp number comes first or the email later. Am I right?
Yes,
Yes,
sir.
sir.
Right. Yes, tell me. Let
Yes,
me
sir.
know. Let me see whether what sequence I followed. Because there is a procedure would be there. You cannot write whatever you like it. Am I right? Yes. And here, Professor Dr. Mohammed Saheb Hussain, asterisk I put. What is the sequence I made? First, occupation, means designation. Next, affiliation. Next, place of the place. Next, country. Next, area. Next, WhatsApp number. Next, next.
Email.
Email, sir.
Why you are taking so much time to give the answer? So that is the way of giving the particulars. And all the parties, you have to follow the sequence. The particulars of the party claims are defenses. What claim they want, the defenses the party is claiming. Every decree shall contain the details of the claims and the defenses the parties are claiming as an outcome of this said suit. Means your plea, your defense, the relief or the remedy granted to the aggrieved party. What type of the relief should be granted? What should be the remedy should be given? What solution should be the justification? The decree should in a particular mention in the relief granted to the particular party as a remedy and not a reward. It is a remedy, it is not a reward. What is reward? What is award? Yes. What is reward and what is award? It is specifically mentioned would be there, it is a award. But extraordinary thing that you have to given is called reward. This is my explanation. If you won the game, award is given to you. If you super made in the game, a reward would be given to you, which is not specified there. Extra. This is my explanation. I may be wrong. What do you say? It's my opinion. The total amount of the cost incurred in the suit. By whom? Or out of what property? And in what portion they are paid and they are to be paid. It should be specifically mentioned. The judgment's date of the pronouncement of a delivery date of the judgment. The decree should mention the date on which the judgment was delivered and followed by the decree. So the sequence should be maintained over there. The judgment date, the decree date also. And the decree implementation, if you want to make it out, it comes in the form of order, and which is nothing but what should be done and what should be given. It passed by the competent court, which passed the decree. So judgments, date of the pronouncement or delivery date of the judgment. The decree should mention the date on which the judgment was delivered, followed by the decree. So that would be an idea. Kausia, you can mute it. I am getting the sound. So when you speak, you can unmute and speak. So here, when it is judgment is delivered, when it is pronounced, that would be clearly mentioned in the decree. The decree should mention the date on which the judgment is given. Still 5 minutes are there. The judge's signature on the decree. The judge's signature is an essential and indispensable element of any decree. The signature of the judge delivering the judgment is an essential requirement. When you want to take a copy, whose attestation is must there? Again the same judge or any other competent person having a right to make that attestation? Answer. Unmute and give me the answer. If you know it, tell me. If you don't know it, you say pass on.
Any authorized question also can be, sir, on behalf of judge.
When you want to take the judgment copy or any copy from the court, whose attestation is essential? The same judge? Did you study anyway 10th class or intermediate or degree? Tell me yes or no.
Yes.
When you apply for the bus pass, on bus pass, who will sign? Vice Chancellor, Registrar, Head of the Department, Principal, Vice Principal, or Superintendent? See, I gave the so many options. Sir, Vice Chancellor will sign. Thank God you did not say Chancellor will sign on the bus pass. Who will sign on the bus pass? Sir, we did not take the bus pass, sir.
Maybe depot manager, sir.
Yes?
Depot manager, sir.
You are a bona fide student of the college. When you want to make it out, who will sign?
Head of the
A
department,
school.
sir.
Head of the department or principal, we can take.
Generally, these things will be assigned to the superintendent. If you take a driving license also, the RTO will not sign on your driving license. It is only the superintendent of the RTO office will sign on but sanction would be there from the RTO. It's a prerequisite. Is it clear?
Yes, sir.
Okay. Now let us go to at any time it will stop. Drawing up of a decree. How a decree will be drawing up? The Rule 6, capital A, Order 20, Code of Civil Procedure 1908 states that a decree shall be drawn within 15 days of the judgment. How many days? 15 days of the judgment. A decree should be drawn. An appeal can be favored or preferred without filing a copy of decree if it is not drawn within 50 days of a judgment. In case the decree is not given over there, without the copy of a decree, one can file a case in the court of law. For the appeal, I am speaking. Is it appeal against a judgment or is it appeal against a decree? When the decree is not passed, then the essence of the judgment, which will be requisite of the decree, on that basis they can make it out. Even the decree is not passed. Decree in a special cases. In a lawsuit for the recovery or the process of the regaining. Okay, let me make it next class, this one. And tomorrow, most probably, I'm traveling. If the net facility is there, I can take the class tomorrow. If not, I will advance inform you. But you read the central idea of the Civil Procedure Code. What Civil Procedure Code says. and what are the content should be there in the civil report, and how it can read it, and you can go through it. And if you want, I can post this handout to your WhatsApp. Meanwhile, you can read it. So the next class, when you come, it will be easy for us to.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा। विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा। तव शुभ नामे जागे, तव शुभ आशीष मागे। गाहे तव जय गाथा, जन गण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
We live in a world full